Good morning. I'd like to call this hearing to order and welcome everyone here today for the Surface Transportation Board's public hearing on paper barriers in the proceeding entitled STB ex parte number 575. I'm pleased that today's hearing is being simultaneously video webcast and is available for viewing through the board's website. I'd like to welcome all those who are tuned in and watching over the internet, in addition to those who are here in person. Vice Chairman Mulvey and I are aware of concerns that have been raised about so-called paper barriers. The Western Coal Traffic League has filed a renewed petition requesting that the board adopt rules to limit the extent to which agreements for the sale or lease of railroad lines by larger railroads to existing or newly created short line railroads may contain paper barriers that restrict the incentive or the ability of the purchaser or tenant to interchange traffic with connecting carriers that can compete with the seller or landlord carrier. The board has received written comments from the interested parties in response to the petition, and the board is holding this public hearing to further explore this matter. With that background, let's turn to today's hearing. We have a number of interested parties that will testify. Some of the questions that may be raised concern our statutory authority to address pre-existing paper barriers, the short and long-term economic effects of paper barriers, the specific proposals for action from those opposed to paper barriers, and other matters discussed in our notice announcing the public hearing. In particular, there is a threshold issue that we would like the parties to address. There's been discussion about antitrust immunity attaching to these transactions resulting from board approval. The vast majority of these transactions, however, appear to have been approved under 49 U.S.C. 10901. and more recently 49 U.S.C. 10902 enacted by ICTA, or have been exempted from those provisions. But under our statute, federal antitrust immunity is specifically conferred only on transactions approved under or exempted from the provisions of 49 U.S.C. 11321 through 11328. Thus, participants should address whether interchange restrictions created by short line spinoffs under sections 10901 and 10902 are subject to federal antitrust law and whether parties are able to pursue relief in court under those laws. The board, of course, must maintain an open mind about all these issues until all the testimony, both oral and written, has been given full consideration. I plan to proceed straight through the witness list today in order until all speakers have been heard. I do not anticipate at this point the need to provide a break for lunch. I will now turn to Vice Chairman Mulvey for his opening statement. Vice Chairman.
Thank you, Chairman Buttry. Good morning, and let me add my welcome to our panelists and those attending the hearing today and those watching on the internet. The board has been petitioned to address the concerns of various shippers and short-line railroads with regard to paper barriers. Some shippers have argued that paper barriers seem primarily designed to limit competition and frustrate the promise of deregulation. Many railroads, on the other hand, claim that paper barriers are necessary, indeed vital, to make it possible for Class I railroads to sell or lease track to short lines. I am most interested in hearing from the panelists about their experiences with the paper barriers, the economic justifications for their existence, and any resultant anti-competitive effects. I am particularly interested in views as to why paper barriers need to be perpetual in nature rather than time-limited. I believe this hearing is an important step in exploring the ways in which the board can be helpful in this area, particularly in deciding whether or not to open a rulemaking on this subject. Thank you, Chairman Buttry.
Thank you, sir. We'll now call the first panel, identified as Panel 1 of the notice of the hearing. Speaking will be representatives of the Western Coal Traffic League, Alliance for Rail Competition, American Chemistry Council, Edison Electric Institute, and the National Grain and Feed Association. Our process today will be that for each panel. We will be first hear the testimony of all witnesses on the panel. I'd like to remind all witnesses that we have read the testimony that has been submitted. Therefore, each witness should summarize their presentations and emphasize the main points they'd like to make so as to stay within the time allotted. Following the testimony, we will turn to questions with myself and Vice Chairman Mulvey, alternating questions, and generally limiting ourselves to 5 minutes apiece. I would appreciate it if each witness would identify himself or herself at the beginning of their testimony. And let's begin now with the Western Coal Traffic League. Thank you.
Good morning, Chairman Buttry and Vice Chairman Mulvey. My name is David LaFerry. I'm the Manager of Fuels for Kansas City Power and Light. and the current president of the Western Coal Traffic League.
Is your microphone on?
I think so.
Just move a little closer.
WCTL is a voluntary association of shippers whose members annually purchase and transport in excess of 140 million tons of coal produced in the western United States. And for most WCTL members, those tons are moved by rail. It is WCTL's position that the continuing enforcement of unreasonable paper barriers is inconsistent with the National Rail Transportation Policy. Through the preservation of monopoly control over a given destination, paper barriers prevent the shipping public from enjoying the benefits of competition between rail carriers. WCTL, as you know, was the party that filed the petition in 1998 requesting that the board limit the use of unreasonable paper barriers. And after more than 6 years' experience under the Railroad Industrial Agreement, WCTL was the party that filed the renewed petition that the board is considering today. In its filing, WCTL has proposed regulations concerning unreasonable paper barriers that would create a rebuttable presumption that any paper barrier that has been in effect for more than 5 years is unreasonable. WCTL's proposed regulations also address the subject of structure of paper barriers, suggesting that a paper barrier should be found to be unreasonable if it penalizes the purchaser for interchanging traffic with a carrier other than the selling carrier, even if the level of traffic interchanged with the selling carrier is not reduced. Finally, WCTL has proposed that the board consider whether the rental or sale price for a given line reflects a return of more than the railroad's cost of capital on the fair market value of the properties that are sold or leased. I will not go into details regarding the Railroad Industrial Agreement this morning, but as we explained in our comments, that agreement is an inadequate solution to the paper barrier problem. The agreement was negotiated between two portions of the railroad industry. It lacks a meaningful definition of what an unreasonable paper barrier is, and it does not provide any direct opportunity for enforcement by shippers. One of the most common points raised by the carriers in their comments in this proceeding is that paper barriers do not reduce the number of competitive services for a given shipper. WCTL submits that there is more to this issue of unreasonable paper barriers than simply the numbering of service options. The nation's railroad industry has undergone a remarkable consolidation over the last 15 years, with far fewer Class I railroads to compete with one another. In addition, the recent widespread use of public pricing by the rail carriers on coal movements has transformed the manner in which we do business and has coincided with a rapid escalation in railroad prices. As the WCTL described in its 2005 renewed petition to eliminate paper barriers, this tremendous consolidation in the rail industry prompted the board to announce a new policy in Ex Parte 582 that parties seeking approval of merger of two Class I railroads now must demonstrate that the proposed transaction would enhance competition. WCTL submits that the same policy goal warrants inquiry by the board into the nature of paper barriers. Where there has been an overall reduction in intramodal competition, the board should view limitations on the use of paper barriers as one way to restore some competitive balance to the industry. Another point that the railroads have stressed is that paper barriers can be necessary for financial reasons. WCTL does not dispute that point. We do disagree, and we believe that the board should draw reasonable distinctions between paper barriers that act as a legitimate vehicle for the financing of underfunded short lines to acquire rail lines, and paper barriers that amount to permanent restraints on competition. At some point in the life of a paper barrier, a Class I will have recovered the reasonable value of the line that it has sold or leased through the rates on its long-haul traffic. The continued enforcement of the interchange barrier beyond such reasonable point in time serves no public benefit. It simply allows the Class I carrier to extend its monopoly control over a destination into perpetuity. Under WCTL's proposal, if a carrier were able to demonstrate that some valid economic reason supported the continued existence of a paper barrier beyond the 5-year period, the board could decline to find that the paper barrier is unreasonable. In the majority of instances involving paper barriers, that have been enforced for periods of time longer than 5 years, we believe there is a presumption regarding the unreasonableness of continued paper barrier enforcement, and that that's a valid assumption. In conclusion, it's important to distinguish WCTL's opposition to unreasonable paper barriers from the railroads, paper barriers from what the railroad sometimes criticizes efforts to obtain widespread open access. Paper barriers to interchange only arise when an individual Class 1 carrier has made an affirmative decision that it can maximize its profits by selling or leasing a specific portion of its system. So it's the Class 1 carriers themselves, not the shippers, not the board, that make the decision to divest a portion of their system. It is entirely reasonable that in these instances, the board should seek to enhance competition between the carriers. Thank you.
Good morning, Chairman Buttrey, Vice Chairman Colby. My name is Andrew Colasar. I'm an attorney with the law firm of Slover and Loftus, and I'm here this morning on behalf of the Western Coal Traffic League. The issue of unreasonable paper barriers has been of concern to WCTL for a number of years, and we thank the board for its willingness to consider this issue here today. It's evident from the comments that have been filed in this proceeding that paper barriers are extremely common. Although shippers typically don't have any information about the paper barrier restrictions that apply to their traffic, the rail groups that have participated in this case have suggested that there may be hundreds of paper barriers that are currently in existence. It certainly appears to us that if the board were to calculate the total number of short line carriers that are subject to paper barrier restrictions and the total volume of traffic that's subject to paper barrier restrictions, it would find that each of those totals is extremely large. And thinking about those totals might be the best way for the board to develop an understanding of the nature and scope of this problem. We expect that the board would be concerned if there were a Class 1 carrier that had agreed that it would not interchange any traffic with another rail line. The only difference in the current situation is that the railroad making the agreement that it will not interchange is a short line carrier. It seems to us that the same policy reasons that would cause you to be concerned with the Class 1 agreement of that nature ought to apply with equal force in the short line situation, particularly whereas here there is so much traffic and so many short lines that are subject to these types of restrictions. The board's authority to address pre-existing paper barriers is based upon the board's reopening and revocation powers, and those are drawn, of course, from Section 722 and Section 10502D of Title 49, and upon the board's statutory authority to prohibit unreasonable practices under Section 10704A1. In their reply comments in this proceeding, the railroads have taken exception with each of these points, based largely on the argument that if the board were to grant the relief that WCTL seeks, it would be engaged somehow in a form of retroactive rulemaking. We think this argument confuses the nature of the relief that WCTL is seeking. In particular, if the board were to grant the relief that WCTL has requested, it would only address the future enforcement of a pre-existing paper barrier, rather than to somehow undo the original transaction, or to penalize the Class 1 carrier for its past actions, or to take away any of the revenues that it's received for those many years on its long-haul traffic. One of the underlying assumptions of the railroad's filings in this case is that if the board were to take any action with respect to paper barriers, it would be financially adverse for the Class 1 carriers, and that they would lose their traffic or terminate their existing leases. And the railroads rely on this argument, of course, to support their view that you do not have the authority to address pre-existing paper barriers. We don't believe that the railroad's assumption in this regard or their related arguments regarding your authority are correct. A finding that the continued enforcement of a paper barrier constitutes an unreasonable practice would not guarantee that the leasing or selling Class 1 carrier would lose its traffic, only that it would have to face competition. It may very well be the case that the leasing carrier that is no longer permitted to enforce its paper barrier has a routing advantage or may have some other efficiency advantage over a rival Class 1 carrier that will ensure that it will keep all of its prior traffic and will do so at the rates that it charged in the past. If that type of advantage exists, then there will be no economic impact associated with the elimination of the paper barrier. In addition, it's possible that if the board were to look at a given paper barrier, it might find that it is only unreasonable to the extent that the penalty provision exceeds some reasonable level. In any event, a Class 1 carrier that currently benefits from an unreasonable paper barrier would only lose its traffic where another Class 1 carrier is able to offer a lower rate for comparable service. And if that happens to be the case, then the Class 1 carrier's real complaint is that the board hasn't been willing to shield it from competition where it otherwise couldn't compete. There is nothing in the rail transportation policy, in our opinion, that requires this board to protect rail carriers in that situation. One of the other arguments raised by rail carriers in this case is that the railroad industry agreement is sufficient to protect the interests of shippers, and that the small number of disputes under that agreement confirms that it is working properly. An agreement between the two groups of rail carriers that were responsible for the creation of paper barriers cannot be expected to constitute a legitimate surrogate for regulatory oversight. We certainly understand the railroad's objection that shippers are not often allowed to participate in negotiations between carriers, but we think it's also the case that private agreements between carrier groups aren't often used as a basis for refraining from regulatory action. Before I conclude, if I have a moment, I wanted to address the question that you raised, Chairman Buttry, about antitrust immunity. It's certainly correct, as you mentioned, that antitrust immunity extends under the statute to transactions under 11323 and following. Whether paper barriers are something that shippers could challenge in court is certainly an interesting question, but I don't think that that really in any way removes this agency's authority and obligation to ensure that they are protecting the public convenience and necessity in any situation in which a railroad is divesting itself of a part of its system. Each of these transactions is one that comes before you where you have the authority to uphold the public interest. And you therefore have the obligation to make sure you're doing that, and if a paper barrier will limit that public interest or interfere with that public interest or has interfered with that public interest, then we think you have the authority and the obligation to take some action. In conclusion, we appreciate the opportunity to present these comments here before you today, and we request that you grant WCTL's renewed petition. Thank you.
Chairman Buttry, Vice Chairman Mulvey, thank you for the opportunity to appear today. My name is Mike Grisseau. I'm Executive Director of the Alliance for Rail Competition. The Alliance for Rail Competition was created in 1997 by a group of captive shippers who wanted to find solutions to the problems that came along with their captivity. ARC has as its members some of the largest electric utilities, the largest chemical companies, manufacturers of finished goods, and a great many agriculture commodity groups. We feel that the diverse nature of our membership gives credence to our ideas and our drive for real marketplace in freight rail. Whenever I speak, I always take care to state that I believe railroad executives to be good and honorable people, working hard to return equity to investors using every tool available to them. My members are simply weary of being one of those tools. Mr. Chairman, I've been Executive Director of ARC for 3 years now, but this world of freight rail was new to me. For 24 years, I've made my career on Capitol Hill. I do legislation and public policy. I wasn't a transportation expert, but I catch on fast. What I quickly learned is that this world is bizarre. When I try to explain the issues of captivity to uninitiated civilians, they find it hard to believe. I get wrinkled brows, and invariably they say, that just doesn't make sense. Indeed, when public policy creates sides, which then wrestle so violently against one another, it's solid proof that dramatic change is needed. The railroad-shipper relationship is poisoned right now. It is poisoned by policies and regulations which pit good people against each other, people who should be acting as partners, people who should each be cheering the progress and the prosperity of the other. In this bizarre world we find ourselves in, market forces determine the size of the pie, but the shape of the pie is driven by public policy. What we have right now is a disfigured confection that starves some while it engorges others. Shippers are starved for balance. And in the entire glossary so familiar to freight rail, bottlenecks, demurrage, standalone cost, the one that makes least sense of all is what brings us here today, paper barriers. The notion that competition can't happen when there are true rail infrastructure alternatives is really just baffling. Now, these barriers, some are legal provisions and sales contracts, and others are physical, like when the Class 1 railroad retains ownership rights on both sides of an interchange point. The former are called paper barriers, the latter are sometimes called steel barriers, but ARC will use the term paper barriers to refer to all of them. The only remotely logical justifications for barriers of this kind were arguments in old ICC decisions, but those decisions were issued at a time when the major railroads' financial health was uncertain. Today, major railroads are enjoying record revenues and profits. Today, we call upon the board to issue a notice of proposed rulemaking calling for additional evidence on paper barriers. At a minimum, the board should also announce its intention to prohibit such barriers in future agreements, while encouraging continued sales of unused or underutilized line to short line operators. In addition, the board should propose new procedures for the termination of paper barriers approved years ago, when Class 1 railroads' financial strength was less apparent and when the industry was characterized by excess capacity. There is a real need to gather information on this issue, in particular because so many, if not all, of these agreements are confidential in nature. It's therefore hard to judge the damage or the harm that's being done out in the marketplace. We understand that the ICC may have wanted to err on the side of promoting railroad revenue adequacy when it approved some of the earlier line sales with paper barriers. But times have changed, and too much rail-to-rail competition is not a problem today, assuming it ever was. The Class 1's financial health today is excellent. Norfolk Southern was found revenue adequate in 2004, and ARC's research indicate that even under STB standards, the combined revenue shortfalls of BN, UP, CSX in 2004 was around $4 billion. That figure will be smaller now in light of the record profits. In addition, Congress may soon provide $25 billion in investment tax credits to the railroad industry to address infrastructure concerns we all have. Obviously, a $25 billion infusion of capital will more than offset the shortfall found by the board in 2004, pushing the railroads far above revenue adequacy. Concerns about revenue adequacy should therefore be tempered by recognition that too much differential pricing is going on. If the railroads can raise the capital they need in financial markets like other businesses, they should no longer be protected from marketplace competition. Economic power is as likely to corrupt as any other kind, and the short line railroads can help provide needed competition if allowed to do so. If the board looks beyond the short-term interest of railroads, it will face considerations like the following. Rail capacity is tight, and the problem is exacerbated by congestion. Railroads are demarketing freight by declining to provide service or imposing high rates to discourage requests for service by disfavored customers. Railroads have shifted the burdens of supplying most rail cars to shippers and often auction car supply. Captive and non-captive rail shippers complain of poor rail service. Captive and non-captive rail shippers complain of excessive fuel surcharges and other charges which this board is gathering information on at this point. It is only through an end to paper barriers that short lines will have the ability and the resources to contribute to solving these problems. Improvements will come both because some of the burdens now borne by Class 1s can be shifted to short lines, and because short line competition will result in greater efficiency and better service by Class 1s themselves. ARC recognizes that the lion's share of the coal hauling in the United States is done by Class 1s. However, the railroad industry is a network industry, and improvements at one location over a one-line segment can permit efficiency gains elsewhere on the system, including lines hundreds of miles away. For this reason, ARC believes that the board should not focus on isolated locations in this proceeding. Instead, it should explore where the rail transportation system as a whole suffers from reduced capacity and efficiency when service and competition from short lines is circumscribed. In ARC's view, the answer is clearly yes. We believe this proceeding will produce more than enough evidence of a problem which requires corrective action for the board to proceed to the next step and issue a notice of proposed rulemaking on paper barriers. It should also use its authority to preclude the avoidance of competition and capacity enhancement for short lines through tactics such as discontinuances of service or planned obsolescence of track segments that short lines could operate more efficiently. The board should also propose regulations phasing out paper barriers in previously approved line sale agreements. I want to take just a moment to remind us all of something that we all know, but I don't hear it mentioned enough in this community. In the proceedings and the day-to-day business of this board, we know that shippers and railroads are very active, with lawyers, economists, and experts all making their case. But there's another group represented in this room every day, the American taxpayers. They hold the trump card around here, not the railroads, not the shippers. So who represents the interests of the taxpayers? Of course you do, Mr. Chairman, and you, Vice Chairman Mulvey. I have come to know some things about each of you. I know that both of you are intelligent, hardworking, experienced professionals who could, at this moment, be doing something more lucrative than you are, but you've chosen to serve. I believe that taxpayers know things aren't perfect, but I also think they believe that in the long run, the American system is fair. They believe that the economic engine that drives the country is sound. I don't think they think about it very much when they flip on a switch and the lights come on, when they go to the grocery and there's abundant food, or when shiny new cars beckon them from dealerships. Whether they think about it or not, they have come to have a silent confidence in the fairness of America. They are so confident that the vast majority of Americans get out of the bed every day and go to work without giving much thought to the STB. That's because they have you here, Mr. Chairman, Mr. Mulvey. So I want to express my gratitude for all who work at the STB, and to thank the board members for taking up the mission of seeing that that silent confidence of the taxpayers is fulfilled. Thank you.
Good morning, Chairman Buttry, Vice Chairman Mulvey. I'm Tom Schick. I'm with the American Chemistry Council. Thank you for the opportunity to be here this morning on this panel. American Chemistry Council, ACC, is pleased to be here to represent our members and to present views on paper barriers on short-line railroads. ACC represents the leading companies that are engaged in the business of chemistry. Under our Responsible Care Initiative, the 129 member companies of ACC have committed to implement a set of goals and guidelines that go above and beyond federal regulations on safety, health, security, and the environment. ACC's members account for about 85% of the productive capacity of basic industrial chemicals in the United States. Each year, chemical shippers depend on the U.S. railroad system for the safe, secure, and efficient delivery of approximately 170 million tons of products that provide rail carriers with over $5 billion in annual revenue. ACC believes that short-line paper barriers have long been recognized as constraints on competition in the rail industry. We request that the board take immediate action to remedy the unreasonable and anti-competitive effects of paper barriers. As you know, paper barriers are conditions attached when a Class 1 road transfers a portion of its track to a short line operator. If a short line is created from track that connects both to the former owner and another railroad, that traffic could be interchanged with either of those two line haul carriers. This practice would not only allow the short line to do business with both of the connecting Class 1 railroads, but would also provide shippers or consignees on those short lines to have access to both line haul carriers for service. When track is transferred to a short line under conditions that impose paper barriers, competition is clearly constrained. Furthermore, the board's approval of such transactions gives the government sanction to anti-competitive conduct. Now, ACC understands and appreciates the economic circumstances under which, over time and with the board's permission, Class 1 carriers engage in the rationalization of their rail systems and transfer lines through abandonment, lease, sale, etc. But as the only agency which is charged with regulatory supervision of these transactions, the board should not simply accept each paper barrier that is presented as a condition of sale. Your decision in this docket observed that the comments that were filed in response to the Federal Register notice in February raise issues that merit consideration by a public hearing. We applaud you for taking this step in what has unfortunately become an overly drawn-out review of paper barriers. This is not a new issue, certainly. Paper barriers were a subject of concern to shippers in this very docket, Ex Parte 575, 8 years ago. At that time, the AAR and the American Short Line and Regional Railroad Association entered into the Railroad Industry Agreement. By its terms, however, that is a very limited agreement because it only applies to traffic that is deemed to be new to rail, new traffic to rail. So the RIA itself perpetuates the captivity that exists when a short line is spun off by a Class I railroad subject to paper barriers. In other words, the RIA does nothing to enhance competition, as the previous speakers have noted, for shippers that are served by only one railroad. Among ACC members, for instance, 63% of the rail-served facilities that manufacture chemicals receive service from only a single railroad. Your approval, the board's past approval or future approvals, or exemptions of paper barriers in individual transactions constitutes a failure to promote competition. This is clearly inconsistent with the statutory mandate to the board. If you take a look at the rail transportation policy in section 10101, you will see that you are to allow to the maximum extent possible competition and the demand for services to establish reasonable rates for transportation by rail. You're to ensure the development and continuation of a sound rail transportation with effective competition among rail carriers. You're to ensure effective competition and coordination between rail carriers and other modes. You're to reduce regulatory barriers to entry into and exit from the industry. And you're to prohibit predatory pricing and practices to avoid undue concentration of market power and to prohibit unlawful discrimination. So it seems pretty clear that the board's continued regulatory approval or its continuation of exemption of paper barriers is inconsistent with the competition that Congress has called for in the rail transportation policy of this country. We're also concerned that the board, while aware of the paper barrier controversy for many years, has failed to take decisive action. Indeed, it was December 21st, 1998, when the Western Coal Traffic League filed a petition requesting a rulemaking to eliminate unreasonable paper barriers, not all paper barriers, unreasonable paper barriers. The following year, the board deferred action on that petition in order to gather more information about the effects of the Railroad Industry Agreement. So that would have been 1999. Paper barriers have also been the subject of legislation that was introduced in both houses of Congress for the past several years. Current bills address this issue, S919 in the Senate, Section 103, S2047, Section 4 of that bill in the House. Both these bills would prevent the board from approving or from exempting paper barriers. In addition, both the bills would permit parties to previous short line transactions and shippers to request that the board review and potentially terminate paper barriers where they're found to be anti-competitive. The references in these provisions to the antitrust laws are significant. Each of them looks at the antitrust laws as a model in that section or a reference in that section. Paper barriers are the very kinds of conditions which, if observed in other industries, would raise serious antitrust concerns. As the agency whose regulatory authority provides the basis for what is less than complete application of the antitrust laws in the railroad industry, you therefore have a special obligation to correct this problem. So we're here at the hearing to gather views on paper barriers, and ACC respectfully requests that the board take either of the following two actions. If you believe you have the statutory authority to prohibit paper barriers in future transactions, and to review paper barriers that now exist, then we request that you promptly open a proceeding which will lead to a rule that will promote competition in this regard. On the other hand, if you and your advisors believe that you do not have the statutory authority, we would like you to join us and promptly recommend to Congress the enactment of some very carefully tailored paper barrier legislation that would allow you to go ahead and do this. In conclusion, we thank you for the opportunity to comment on the impact of paper barriers on competition in the railroad industry. We think that after 8 years, it's time for the board to take meaningful action and to eliminate unreasonable paper barriers. Thank you.
Good morning, Mr. Chairman, Mr. Vice Chairman, staff. Mr. Chairman, my name is Michael F. McBride. I appear on behalf of Edison Electric Institute, the Association of the Nation's Investor-Owned Electric Utilities. Let me go straight to the question that you asked us to address this morning. If the STB were to take the position that paper barriers that had been exempted from regulation by this board or otherwise approved by this board, but that had not been approved under 49 U.S.C. 11-321-28, were somehow subject to antitrust regulation or litigation, I think you might be met, or if a shipper took that position, the shipper might be met with the following argument from the railroad.
Number one, that in addition to the statutory provisions you cited, there are broad exemptions for railroads under the Sherman Act and the Clayton Act. Number two, in the Supreme Court's decision in 1922 in Keogh, Mr. Justice Holmes seemed to say that anything that the ICC regulated or could regulate, that is subject to regulation, is immune from antitrust regulation. And number three, about 2 years ago, I seem to recall, in response to an inquiry from Congressman Sensenbrenner, the chairman of the House Judiciary Committee, the Department of Justice weighed in on this subject and seemingly said, if I recall correctly, but subject to check the letter which I do not have here with me, that regulation by this board might prevent the application of the antitrust laws to matters that you have the authority to regulate. I'm not saying that those arguments would prevail or that they are still correct. I'm simply suggesting to you that the matter may not be so simple as whether you have or have not approved the matter under 11.321 to 28. In any event, let me address some of the same topics the other speakers have here this morning and echo some of the points they made and make a few others. Edison Electric Institute didn't participate in this proceeding until recently because members of the EEI only recently brought to its attention through their comments in this proceeding the problems they were having with paper barriers at their facilities. So we're pleased to endorse the positions of Ameren and Kansas City Power and Light, and through it the Western Coal Traffic League and Entergy, and endorse those comments as our own. Let me just make a few brief points about why we have a concern here. Paper barriers by definition are anti-competitive. The railroads will say that they don't change the status quo in many cases, but that's not the answer to the question. Paper barriers exist to restrict competition with another railroad with whom that short line may connect. And whatever the merits of approving the paper barriers in the past, today we're in a different world. As Mr. Grisso has already alluded to, the railroads are far more financially healthy than they were. And as your recent letter to railroad CEOs indicated, Mr. Chairman, we are now living in a world of capacity constraints in the railroad industry. And it therefore may be very timely for this board to take another look at whether public policy now suggests that paper barriers which inhibit competition and frustrate the ability to use existing rail capacity are contrary to public policy. We think, frankly, they are bad public policy, and you should not approve paper barriers in the future. There are other contractual restrictions in this industry that similarly cause problems. As I alluded to in our written statement for EEI, you might look at the case of State of Minnesota by BN Railroad Company versus Big Stone Development Company. The citation is there, which prevented Otter Tail Power Company from building out to reach a short line 2 miles from the power plant, and which inevitably led to the rate case that Otter Tail Power Company then had to bring to this board. Had it been able to build out, that rate case might never have been necessary, which is an illustration of the larger problem that we face, and that is, if the board is not going to find paper barriers to be contrary to public policy, there is no substitute for your authority and your intercession to regulate the anti-competitive problems that inevitably result from such barriers. It's one or the other. We would much prefer competition, but we'll take regulation in the alternative. And so let me just conclude by saying that I think you have the authority to act, and I think it's timely for you to act. The world has changed, and your policies can change with it. You'll have the authority at any time to reopen a prior proceeding or to revoke an exemption. I would encourage you to do so. I would encourage you to institute a rulemaking. There's more than enough evidence of record in this proceeding to cause you to do that. I'd be happy to answer your questions. Thank you.
Good morning, Mr. Chairman, Mr. Vice Chairman. I'm Andy Goldstein. I'm appearing today on behalf of National Grain and Feed Association, which, as you may know, is the oldest and largest diversified agribusiness trade organization in the country, with members involved in grain merchandising, grain exporting, feed manufacturing, grain processing, and the production of ethanol and biodiesels. And we appreciate your courtesy in providing an opportunity for us to offer our comments. NGFA believes that conditions in the rail industry have evolved to the point where it is plainly appropriate that a rulemaking on paper barriers be instituted. The board, we know, understands what paper barriers entail, their conditions placed on the sale or lease of Class 1 branches or other lines, prohibiting the free flow of traffic between that property and any connecting Class 1 railroad. These types of restrictions are far more harmful today than they were years ago when the paper barrier practice began. Light-density rural lines disposed of by Class 1s often generate bulk traffic like grain products in less than train volumes. That's traffic increasingly given poor service or discouraged entirely by Class 1 railroads today. Shippers on light-density lines have a greater need today for routing alternatives than ever before in order to seek out routes where their traffic is welcome and given acceptable service. Allowing shippers on paper barrier short lines to have access to competitive Class 1 service is consistent with the intent of Congress. Mr. Schick just recited to you the relevant portions of the rail transportation policy, and I won't repeat them. The conclusion, of course, is that paper barriers simply preclude effective competitive choices by shippers and are therefore contrary to that policy. I'd like to comment on the board's question concerning whether it has the authority to terminate paper barriers. Applicable case law indicates firmly that a rulemaking declaring the prospective invalidity of paper barriers is not prohibited as a matter of law, even if doing so has an impact on existing agreements. The type of retroactive agency action that is prohibited is the type of action that actually alters the past legal consequences of prior actions. For example, if the board were to invalidate a paper barrier agreement as of the date it was entered into and expose the parties to retroactive third-party liability, that action most likely would be a form of prohibited activity. But a rule that has been adopted by the board for prospective application only, even if it undoes for the future, in part or in whole, a bargain made in the past, is a different animal altogether and has been allowed by the courts as illustrated by the cases cited in our filed summary of argument. The AAR, as Mr. Colasar, I think, mentioned, takes the position that the board can't undo paper barrier bargains entered into in reliance on prior decisions approving paper barrier arrangements. Set forth as a strict rule of law, we believe that argument is without merit. Case law requires the board to evaluate reliance arguments, but not to accept them simply as presented. The board must weigh a party's reliance arguments against other considerations, such as whether the extent to which the public interest will be served by a change of policy and whether a new policy is consistent with the statutory scheme, which in this case it is, in order to promote competition. NGFA believes that a rulemaking should be instituted to establish procedures under which existing and proposed paper barrier arrangements can be reviewed under the appropriate balancing tests set forth in the court cases. It's highly unlikely that there is a valid economic justification for a perpetual paper barrier restriction, and a rulemaking should serve to establish ground rules for examining paper barrier agreements to determine at what point they outlive their justification in any particular transactional setting. And if I may, just let me comment also on your question. In addition to what Mr. McBride just said, which I would join him, about it not being as simple as simply what happens to the board's exemption process. There also, I think, has to be considered the question of who would be in a position to bring an antitrust action. The antitrust cases have very strict rules of standing, and it doesn't necessarily follow that if antitrust remedies were available, they would be available to all shippers served by the railroads involved. So again, I would join Mr. McBride in saying it's not a simple question by any means. Thank you.
Well, thank you very much for all your statements, which we found very interesting. Obviously, this subject has created a lot of interest here at the agency, and we appreciate everyone coming forward today to express your views. I'd like to just invite comments from anybody on this panel, and probably ask the questions of others as well who will appear on this issue of restrictions on new customers as opposed to existing customers that might be affected by a paper barrier. Isn't something like that inherently discriminatory under the Act?
Chairman Butcher, I'm afraid I'm not following your question.
My understanding is that there are paper barriers that exist that say you can serve new business, but you can't serve old business, or something to that effect. I actually haven't read very many of these paper barrier contracts, but my understanding is, from being briefed on this, is that there are provisions in the paper barriers that make a distinction between new business and old business, if you will. What are your thoughts on whether that is inherently discriminatory or not?
I'll try to approach that a couple of different ways. One, the new traffic distinction that I'm most familiar with in this context has to do with the railroad industry agreement, and the fact that that agreement will only apply in situations where new traffic exists that the incumbent Class 1 carrier either cannot or will not attempt to serve. As for whether any provisions of the type that you're describing in paper barrier agreements may exist, and whether those are discriminatory, I think it's inherently discriminatory that paper barriers exist in the first place. The whole idea is to discriminate, to allow the shippers to only have service via one carrier. So if those paper barriers exist as you described them, yes, but they're probably part of a much larger discrimination problem.
Mr. Chairman, maybe I could add something to that, and that is that I think you are right that if two shippers are otherwise similarly situated, and the only distinction between them is one was a customer at the time the paper barrier was entered into, and the other comes along later, that one would think on its face that that is the definition of discrimination. The difficulty is, I would submit to you respectfully, that I think it has been at least 25 years since anyone even believed that they could make a case for discrimination before the ICC or the board. I don't think you'll find a case since Staggers Act, and maybe well before, in which the ICC or the board found discrimination on any set of facts. If your question suggests a revival of the old doctrine, I'm cheering you on, but I am concerned that there's a body of case law here that might inhibit the application of the principle that you were just asking about.
And if I may add a comment.
If I was starting a business on near a rail line somewhere, and if I was the person who couldn't get service because of a restriction like that, I think it would concern me greatly. I mean, the whole theory of entrepreneurship is that you start a business and you get service, and to have someone getting service on the line and you not being able to get service on the line, that would concern me. If I were starting a business, I'm not starting a business, by the way, but if I were, I might start one later, but not now.
Let me just add and then let Mr. Goldstein answer. But Big Stone Development Company was trying to start a business, if you will, in the case in which it sought to build out to the short line to be served at Big Stone. And I don't think it matters whether it's new or old. The power plant was there, and they weren't permitted to do business with that short line. So I think the problem is the same, whether it's for the existing customer or the new customer. And that's why I agree with you that it's discriminatory. But I think we'd have some heavy lifting to do to get rid of all those old precedents to be able to make that case.
In the agricultural industry, Mr. Chairman, we have tremendous problems in just getting any new business into the railroad system. And we're finding it more and more difficult. So the problems that we have are really involve existing business perhaps more seriously than new business, which comes in on very defined terms these days.
Mr. Chairman, I would address your question or your concern about discrimination and entrepreneurship very similar to the way that Andy just did, which is I think a shipper is entitled to service whether the shipper is starting a new business or whether the shipper has an existing business. And if that shipper is held captive or doesn't have the alternative of going and having the short line carry the traffic to the other Class 1, while we're all in favor of new business and entrepreneurship, I think we're also in favor of supporting the businesses and the industries and the jobs and the exports that we have in this country. And I think that distinction doesn't really answer the question if you only focus on new business. In fact, as I mentioned in my prepared comments, that's at the heart of the railroad industry agreement, this idea of traffic that's new to the railroad. And that is up for shifting between the one class one and the other. Again, that's a problem because it doesn't address the real fundamental problem, which is the lack of competition for the shipper who's captive on that short line and would like to have access to both class one carriers rather than the one.
Thank you. You always come to these hearings with a lot of prepared questions, and then you hear the testimonies and you come up with different questions. On this issue of the railroad industry agreement and new business, it's been charged that there was different expectations about how this would play out, and that in fact the agreement has not allowed short lines to come in and capture new business because of the way it's been defined. Do you have any specific examples from your industries where what was thought to be new business turned out could not be handled by the short line with another class one because the railroad industry agreement said that new business also came under the paper barrier?
Number one, Vice Chairman Mulvey, I don't have any examples. Number two, I'll go back to my prior comment to the chairman, which is I don't believe that distinction is a valid distinction, that somehow competition should only be available to new businesses or to incremental traffic. And therefore, I haven't been spending the last 8 years looking for examples where something did or didn't work under that new business distinction in the RIA.
Well, I guess the question was whether or not the RIA was working at all, or whether or not it was itself just a piece of paper and not an effective way of overcoming some of the paper barriers for some of the traffic.
Are you suggesting it's a paper barrier itself? I couldn't resist.
You claim that the railroad industry agreement, Mr. Colasar, that it does not define what a unreasonable paper barrier actually is, and it lacks any mechanism by which shippers can participate in that agreement. What changes to the RIA would you suggest, or how would you propose that shippers be part of the process?
That's a good question.
Thank you.
You know, and it was a question I was asking myself. There's a great deal that would need to be done to the RIA to turn it into something that would constitute a proper solution to this problem, we believe. You know, I guess the short, somewhat flip answer is amend the thing so that the replacement is the proposed regulations that we put in place and grant a right to shippers to come in and come to the board and announce that any time that those regulations aren't complied with, we've got evidence of an unreasonable practice. Short of that, you really have a situation where the class ones have the short lines in a situation where the short lines really don't want to do anything to interfere with the class one carriers, and the class ones have unfettered discretion to decide whether or not they'll want to keep traffic. It really hardly seems to be a solution for a class one carrier to say, there's only a problem if we say there's a problem. And if we want to keep the traffic, then we're entitled to. You know, that really is a long, far cry from where we think it needs to be to constitute a solution.
The issue came up about our jurisdiction and the applicability of the antitrust laws. It's been suggested that the courts might say that no, it's STB's jurisdiction and therefore the antitrust laws won't apply here. But this is a very, very controversial issue, and for us to act on paper barriers would mean we would be going back on the implications of the previously approved spin-offs of the short lines, which had those paper barrier clauses in them. So we would be going against our own precedent. Some would argue that doing so would also interfere with contracts between private parties. So it would strike me that if it went to the courts and the courts began to uphold your view that these things were violations of the Clayton Act, then the board would have more evidence in which to make a decision as to what to do with paper barriers. Isn't that true?
Well, let me try to answer what was one of the assumptions in the middle of your question, I think, the idea that this might interfere with private agreements. These are not simply private arrangements. They are by definition public because the railroads involved necessarily under statute have to come to you for approval. And your authority and jurisdiction over those transactions removes them from simply being private agreements. So in that sense, I don't think that you can say that interference there is any problem. Also, whether it might improve your comfort level in addressing paper barriers, if a court told you that they couldn't do anything about it, well, I suppose it could, but that certainly puts the burden on a shipper to have to go out and file an antitrust case when we believe that this agency has the authority and the obligation to act in the first instance.
Mr. Vice Chairman, the constitutional prohibition on impairment of contract only applies to the states and not the federal government, so it's not a limitation on this board's authority. And in any event, I would submit to you for one of the reasons Mr. Goldstein gave about the difficulty of finding someone who has standing to challenge one of these paper barriers. It might be difficult to bring such a case. You'd be met with the arguments that I suggested would be made in response to such a case under the Clayton-Sherman Act. And I think in the end, you're in a greater position to develop the evidence than a court would, or court by court, case by case. But what you could do, I think, perhaps, is following up on Congressman Sensenbrenner's letter, is ask the Justice Department for its views on whether shippers have standing to challenge paper barriers, number one, and number two, whether the antitrust exemption is as limited as to 11.321 to 28, or whether it's broader than that. And I think it would be very instructive to get the Justice Department's views on those questions.
Thank you. I think we'll look into that.
We are concerned, however, about the length of time it would take to get such an answer.
Mm-hmm. That's also a factor. Mr. Griswold, one of your suggestions is the board issue an NPR calling for more evidence on paper barriers. What specific types of evidence would you have the board request from the carriers, the short lines, and the shippers?
One of the problems that we have in developing the rational arguments that to come to you with is the fact that so many of these agreements are confidential. You're the only ones who really have access to them. And opening of the proceeding, and I'm well aware that this has been going on for some time now, but time has passed and times have changed during the time that this proceeding has been open. So we believe that it is relevant to gather new information, and we'll have to use the power of the board to gather specifics on those contracts, knowing full well that some of those would have to be held in executive confidence. But we just believe that this board has the power to, that no one else has, as Mr. McBride says, to take a good look at this and see what those conditions are at this point.
If I may, I'm not certain that may be more of a burden now than is really necessary, given the fact that the board certainly does have in its possession a number of these paper barrier agreements already. We know that we've seen your dissent, by Chairman Mulvey, in the past with respect to paper barrier issues. You've seen them. They're in your hands, so I'm certain that it's really required to go out and start a lengthy proceeding to try to collect them again.
So is it the collective judgment of this panel that the jurisdiction determine whether a contract is either granted exemption from the antitrust laws by the board or not is exclusive jurisdiction of the federal courts? Or is it exclusive jurisdiction, or at least initially jurisdiction of the Surface Transportation Board? The question of whether the provisions of the Act extend antitrust immunity to a particular contract or not, isn't that a subject that's exclusive to the jurisdiction of the federal courts, like in a declaratory order proceeding or something of that nature?
You clearly have the authority and the jurisdiction under 10901 and 10902 to look at the transactions that come before you and ensure that they're consistent with the public interest. I think that's all the jurisdiction that you need to address this situation.
Mr. Chairman, I think there's a two-part answer to your question. First of all, I think it's clear that this board had the authority in the first place to determine whether to approve paper barriers, and it did so through a class exemption in general. It has the authority to revoke that in whole or in part, has the authority to look at each of these agreements before they're approved. It certainly has the authority to distinguish between agreements that it may conclude are anti-competitive and others that for some reason may not be, for example. So you plainly have authority with respect to the approval or the disapproval of the agreements in general or specifically. If your question, however, and now I'm going to the second part of my answer to your question. If your question is who has the authority to determine the full extent of antitrust exemption that may apply given this board's regulation or authority, that may indeed ultimately be a question for the federal courts to answer. I think you could weigh in on the question. Whether your views were given any deference ultimately by the courts is a difficult question. Perhaps I'm not sure I know the answer to that, but I do think they'd probably give your views at least respect, if not deference, because to some extent you do regulate, and by doing so oust the antitrust regulators of authority, at least to some extent. And so there's a line to be drawn there between what you do and what they do. And yes, ultimately I think the courts will have to answer this question, and that's why I suggested you get the views of the Justice Department about this. But I don't think you're completely incapable of addressing the question.
I don't mean to put words in your mouth, Mr. Goldstein, but you seem to be saying that a shipper might not have standing to attack a paper barrier contract between a short line and a Class 1 railroad. Is that what you? That's what I thought I heard you say. Is that what you said? And how would the other panel members feel about that?
No, I think what I was commenting on, Mr. Chairman, was your question about what the consequences would be, or at least your question as I understood it, and may have misunderstood it. It
may have been a bad question.
No. What the consequences would be if the antitrust laws were applicable. And in that context, I was suggesting that that might not be a simple solution from a shipper's point of view, because there are standing questions about the ability of a shipper to bring a complaint alleging that the short line railroad that serves the shipper and connects with a large railroad is being denied access to the rail system. And that was all I was talking about.
Yeah, that's what I thought you were talking about, and I was wondering how the other members of the panel might. Do you have the same question about whether there would be standing or not?
There is a question. There's a case referred to as Illinois Brick, in which the issue is whether the indirect beneficiary or user, if you will, is entitled to bring an action to challenge, or whether only it is the would-be competitor or frustrated competitor who can bring the action to challenge. And there are restrictions on indirect users being able to bring antitrust actions.
I guess that depends on what your definition of independent. What, Frank?
Indirect user.
Yeah.
In effect, a downstream customer, right, beyond that initial transaction. I think that's where the Illinois Brick kind of case falls out. I think it raises some concerns, but I think we're in danger here of sending all of ourselves down another 8 years of legal analysis and wondering and referrals to the Justice Department and things like that, when it's probably time to get moving on this, as on many other matters that the board can address.
There's been some discussion about attempt to sunset existing paper barrier provisions. What's the view of the panel on that?
Well, we think that there's no need to engage in a sunsetting provision. What we had contemplated in our filing was that an individual shipper would have the opportunity to come before the board and seek a declaration that the continued enforcement of an individual paper barrier constitutes an unreasonable practice. We envision that one of those thresholds to be used in that determination is whether the paper barrier has been in existence for more than 5 years. Set that up as a rebuttable presumption. If the rail carrier can come before the board and demonstrate that the continued enforcement of a paper barrier beyond its 5 years, beyond 10 years, beyond 20 years is not unreasonable, then arguably the board could allow that paper barrier to continue for some reason. If that meant that that individual paper barrier were allowed to continue for some years past the time in which you engage in that individual proceeding, then I suppose that's one possible outcome, but I think that would depend upon the proof brought before the board by the rail carrier with respect to one of those older paper barriers.
So you're talking about creating like a new cause of action, if you will, for that type of procedure.
It's an unreasonable practice, and all that we would need would be a regulation that the board proposes that says that when we evaluate claims of unreasonable practice related to paper barriers, these are the things that we'll look at, and these are our presumptions.
Well, this would be on a case-by-case basis then. And
correct.
Theoretically, we could have hundreds of these cases being brought. If indeed there are hundreds of paper barriers out there affecting maybe thousands of shippers. So it would. And how would we go about calculating whether or not the paper barrier was unreasonable or not? How would we calculate whether the railroad recaptured the value of its paper barrier when it created it? What would be some of the elements and factors we would need to consider?
I presume you would take evidence regarding the size of the line that was subject to the lease or the sale, the volume of traffic, the rates that the Class 1 carrier has been able to charge over the years since its paper barrier went into effect since then, since the paper barrier was put into effect, the residual value of the line, what it might have cost to lease the line in the absence of any paper barrier restriction, compare those two, see where the numbers come out. And again, I know I mentioned it in my prepared comments, but I think it bears emphasis again. The elimination of a paper barrier will not necessarily mean that the incumbent Class 1 carrier is going to lose its traffic. It's not a taking in that sense that all of that traffic is being taken away by the agency. They may need to reduce their rates by a penny a ton. They may need to reduce their rates by more than that, and it may turn out that they can't reduce their rates enough to beat the competition because Class 1 carrier B really can get in there and serve that traffic in a more efficient and more cost-effective way. And is that really what needs to be protected? Do we need to protect monopoly rates on long-haul rail transportation? We think the answer is no.
One of the future testifiers estimates the cost of the paper barrier to his firm. I forget what it was, $3.25 a ton, I think, something like that. But there's precious little in the record about what these paper barriers actually are costing. We hardly even know how many there are and what the impacts are. So it's not clear whether we're dealing with a big problem or a small problem. There's also some suggestion that paper barriers, when they were first permitted, were permitted at a different time when railroads were revenue inadequate, or more so than they are today. And perhaps the times they are changing, and there's a new world out there, and that railroads don't need the same kinds of protections from competition that they did, say, when paper barriers were first instituted. Do you want to comment on that?
We certainly agree with that. In fact, that is something that appears in our 2005 renewed petition, that the railroad world has changed, and changed even between 1998 and 2005, as reflected by the board's changed regulations regarding enhanced competition with respect to Class 1 mergers. The world does change, the railroad industry does change, and it's not unheard of for this agency to change its policy on certain matters in response to those changes. We could go through a list of issues in standalone rate cases where one item that has been ICC and STB policy for a long period of time in terms of how you present your evidence and how the board will rule on those issues suddenly becomes the opposite policy, and that type of thing does happen.
But isn't that a little bit different, because now we're talking about the applicability and the validity of whether or not this is an unfair, unreasonable practice, and we're saying that our declaration as to whether it's unreasonable should be a function of the economic environment the industry faces itself? Mm-hmm. Is that acceptable that we can say, well, we thought it was reasonable when the industry was revenue inadequate, but now that the revenue more revenue adequate, it's now unreasonable. Is that something that we could defend?
I think it is defensible, yes.
We would absolutely agree with that. It's just been our policy at ARC, and it's part of the reason why the provision in S-19 is drafted as it's drafted, with the respect to current agreements, so they would phase out. But I would, in terms of precedent, I'm the only non-lawyer around on this panel, I think, so I can just quote poets and encourage the board to do, as Goethe said, be bold and angels will come to your aid.
Mr. Vice Chairman, I would submit to you that there's no question that if the circumstances have changed, that the board can change a policy, and that would likely be given great deference by a court and would likely be upheld. The board has a pretty good track record when it announces policies being upheld in court, so long as it has any authority whatsoever under the Act. In any event, I just want to observe also that I can't think of another industry in which a participant can sell an asset and then restrict the parties with whom the person who buys the asset can do business. And so I would submit to you the answer to your question is that after a reasonable notice period, you should declare that the pre-existing paper barriers no longer can be used in an anti-competitive fashion. You should rely not only on the fact that the railroads are more financially healthy than they were, but also on the fact that we need all the rail capacity we can get in this country and make the most efficient and effective use of it. And to inhibit the use of existing capacity because of some circumstances that may have been in effect 20 years ago when there was excess capacity in the industry and there is no longer, I think would be to tie yourself to the past, and no court requires a regulatory agency to tie its policies to the past.
In your written testimony, you state the STB is mindful of current capacity constraints, and we certainly are. And you urge us to take actions to try and limit such capacity constraints and improve capacity in the railroad industry. But how would acting on paper barriers improve capacity in the railroad industry? How would you get more capacity? It would strike me that would probably put stress on capacity.
The classic hypothetical paper barrier that we're talking about here is a short line that can connect to two Class 1s, but which through contractual restrictions, penalty provisions or otherwise, is effectively required to give most or all of its business to the first railroad. If the first railroad takes you through Chicago and the second railroad doesn't, then I would submit to you that it's a given that by allowing that business to go to the second railroad and bypassing Chicago, you're most likely going to improve the fluidity and therefore the capacity of the nation's rail network. And we could talk about examples like this all day long, so I won't try to come up with other hypotheticals, but I simply make the point to you that there are obvious choke points in the rail system of the United States. And there are innumerable examples, I think, where putting in additional capacity or making effective use of existing capacity has improved fluidity. You see the Class 1s reactivating lines themselves that they previously took out of service for the same purposes. And so I think all over this country you can see ways in which the system would improve if we didn't have these artificial choke points as the problem.
I was just thinking that reducing paper barriers, eliminating them, might lead to somewhat lower rates. That's the expectation. Lower rates, of course, might mean more rail traffic and more pressure on the existing capacity, but maybe.
Well, one of the things we don't know is if there are two Class 1 carriers that could carry the traffic for the bulk of the distance, we don't know which one's more efficient. That's what the market is supposed to find out. And what we're doing, and I think this might be what Mike was suggesting, is that we're freezing and saying it's all got to go on Railroad A. Now, Railroad A may be going through Chicago or not. But the market is to allow whichever of those two railroads, even if it goes through Chicago, the one that has the most efficient route, or over time things change, to get the traffic or offer a better service package, rate or no rate difference, but to offer a better service package and to do it. I think there's a lot of uncertainty, and I understand. I mean, everyone's troubled by things like clauses that are perpetual. That's a really long time. But there's also concern about, is this a big problem or not? And I think that's what you were trying to get at with the last question. You know, are there hundreds of cases out there, or are there only 6? I would submit, since we don't really have a record on that, and maybe the rulemaking would help to build that record, but if there's hundreds of cases, then there's a lot of problems that has to be fixed. And if there's only 6, then it won't be a big burden on you guys to fix 6. So I think we should get on with it.
And I think that the history of regulation by this body in the last 10 years and by the ICC before it since staggers is that you almost never get hundreds of cases on any subject. What happens is that the parties go out and work out commercial solutions once you make clear what your policies are.
Thank you very much. We'll call the second panel now, identified as Panel 2 in the notice. The Association of American Railroads, the American Short Line and Regional Railroad Association, Railroad Industry Working Group, and Union Pacific Railroad Company. Again, we're going to hold all of our questions until everybody's had a chance to speak. We were delayed a little bit this morning. I apologize for the delay because of security concerns, not security concerns, concerning security procedures. I'd like to remind everybody that everybody in this town has gotten a lot more concerned about security. So when you're in the building, you need to be sure and display your badge. I don't mean to pick on you, Mr. Grisso, if you're still in the audience, but I never did see your badge. I'm not sure where you are right now, but I assume you have your, okay, good. So we're looking out for that sort of thing. Otherwise, you might be summarily escorted out of the building, which would probably be an inconvenience. But anyway, we're real exercised about that these days, and so I just point that out. You may proceed, sir.
Good morning, Chairman Buttrey, Vice Chairman Mulvey. On behalf of members of the Association of American Railroads, we appreciate the opportunity to appear before you today to discuss the significance of interchange commitments, or so-called paper barriers, in line sale and lease transactions. As the AAR has expressed in its written submissions in this proceeding, we believe the record shows that paper barriers, which should more accurately be called interchange commitments, are valuable private sector contractual tools that the railroads have used to maintain and grow rail business and to improve the efficiency of rail service to customers. Moreover, there is no basis from either a legal or factual standpoint. Moreover, there is no basis from either a legal or factual standpoint for the board to grant Western Coal Traffic League's petition for a rulemaking that would restrict the rail industry's ability to freely negotiate such contractual terms and thereby deprive the railroads of a proven means to promote rail service. In that regard, viewing these interchange commitments in the context of contractual obligation reminds one that such commitments are not unique and are not made in a vacuum. Comparable provisions that accomplish much of the same results are customarily found in myriad overhead trackage rights, haulage rights, switching agreements, and other cooperative ventures between railroads. And these interchange commitments are not the same in their scope or application, no one-size-fits-all model. They are given in exchange for other consideration. The structure of interchange commitments were and are reflective of factors such as the value of the line, the initial purchase price or lease payment, the expected future revenues, traffic and costs on the line, and the ongoing cooperative relationship that the agreement establishes between the railroads. In the time that I have remaining, I would like to offer 4 observations on the written record in this proceeding, a record, again, which we believe provides no justification, no legal or factual basis for the board to institute a rulemaking proceeding to restrict the use of these interchange commitments. First, the record is unrefuted that these kinds of contractual interchange commitments have contributed significantly to the growth of the short line industry and to the productivity and cost effectiveness of both short haul and long haul rail transportation in this country. Neither the ICC nor the STB has ever found in any individual case that an interchange commitment was itself anti-competitive or that it had resulted in anti-competitive conduct, and in fact there are ICC and board cases cited in the record which state exactly otherwise. The bottom line is that interchange commitments create win-win-win situations where the short line railroad is able to acquire and operate a line that would otherwise be unaffordable. The Class 1 railroad is free to better concentrate its service and investment on its main and other lines with a greater traffic base while retaining the revenues from the line haul operations off of that line. And shippers obtain responsive service on a lower density line which otherwise would not receive investment and service priority. Despite the assertions by the Western Coal Traffic League and other parties of so-called problems with these interchange commitments, there's nothing here that would require a rulemaking proceeding. The record does not support such claims. While arguments have been made that these interchange commitments need to be eliminated to address rate and service problems, the fact is that if a shipper has a rate or service problem, it can seek redress from the board in the same manner as any other shipper located on any other rail line. An interchange commitment on a line does not restrict a shipper's right or place it in any less advantageous position than any other shipper on lines not subject to interchange commitments. As such, these interchange commitments have not resulted in the loss of any shipper rights or remedies or rail options. And in connection with a comment, Chairman Buttrey, that you made concerning new traffic on a rail line, that new entrant onto a rail line where there might be an interchange commitment receives the same service that it would have received if the interchange commitment, if the transaction providing for the lease of sale and had not occurred. There is no loss of service to a shipper locating on such a line as a result of any interchange commitment. When it comes down to the so-called problem that WCTL and its supporters seek to address by the elimination of interchange commitments, the problem is the absence of intramodal competition, the absence of intramodal competitive alternatives, even though such intramodal competition was not present prior to the transaction creating the commitment. WCTL and its supporters are seeking to introduce intramodal competition artificially by regulatory fiat, both in this instance and, as was mentioned in the prior panel, in other regulatory and legislative venues as well. Interchange commitments, secondly, interchange commitments do not constitute a restraint of trade, nor are they otherwise anti-competitive. In answering your question, there clearly is statutory immunity under Section 11323. And as the first panel indicated, it is not clear the extent to which there would be antitrust immunity or protections provided under applications under 10901 and 10902 in view of the regulatory jurisdiction and the scope of that jurisdiction that the board currently has over transactions. But nonetheless, whether or not there is such jurisdiction or not, the interchange commitments, again, do not constitute an unreasonable restraint of trade. They are not anti-competitive. There is nothing anti-competitive about an interchange commitment that maintains the status quo and that has been recognized in ICC and board decisions, and that is all these provisions do. Transactions with these commitments are no more an unreasonable restraint of trade than a railroad electing to enter into haulage, overhead trackage rights, agreements at lower prices than if arrangements were made to include and serve local shippers on the line as well. Such interchange commitments are a sale of limited rights between a willing buyer and a willing seller. The so-called restraint here is no different than a restraint to which a shipper would be subject to if only the Class 1 that was owning the line elected not to enter into the transaction at all. Third, there are significant legal and practical constraints on board action through a rulemaking proceeding or otherwise regarding existing interchange commitments in already consummated transactions. These are not peripheral to the transaction. These are not add-ons. These interchange commitments are core to the transaction, and the elimination of these essential terms would have retroactive effect. They would retroactively abrogate the rights that were vested with the approval of the board, and they cannot be eliminated through effectively a retroactive rulemaking. These types of rulemakings have been invalidated by the courts. Now, comments were made that these only have future application, yet a retroactive rulemaking includes rulemakings that have provisions that impose new duties with respect to transactions already completed, and in this case, there would be new duties and new liabilities upon the railroad even prospectively. And those would be the loss of a line or the use of a line without the adequate compensation that had been negotiated and previously approved by the board. But even assuming that the board had the legal authority to make retroactive rules, the ICC and the board have recognized the unfairness of imposing conditions on transactions years after they were otherwise approved. Moreover, if a contractual interchange commitment was a core component of the transaction and it were restricted or eliminated by regulation, there would be the host of practical and commercial problems that Vice Chairman Mulvey indicated, and that would need to be resolved in subsequent individual proceedings that WCTL even conceded would be necessary. In each individual case, the underlying transaction would need to be reassessed, perhaps renegotiated to reflect the value of the consideration to the parties. The case would be further complicated by having to determine who should pay the compensation, especially when the short line was unwilling or unable to do so. And further, if the selling or leasing railroad did not receive appropriate compensation, it would likely have the right to unwind the transaction. The board would become embroiled in disputes about not only the railroad's respective rights and obligations, but the rights and obligations of third parties who may have relied upon the transaction as well. Nothing would be accomplished except for increased costs for both long-haul and short-haul rail service and diminished productivity, all in the attempt or in the name of trying to solve a non-existent rate or service problem. A non-existent problem because any rate or service problems could already be handled by the board under its existing procedures and rules that apply to any other shipper, whether or not on a line with subject to an interchange commitment. What this does, again, is only attempt to force intramodal competition by regulatory fiat. Lastly, a rulemaking proceeding would restrict the use of interchange commitments, and a rulemaking proceeding that would restrict the use of interchange commitments either retroactively or prospectively, it would represent a marked and counterproductive departure from the board's past encouragement of such cooperative market-based transactions. Both large and small railroads have said in this proceeding that without the opportunity to use interchange commitments, the short line railroad could not afford to lease or purchase the line. The large railroad would be unlikely to lease or sell it if it did not receive fair consideration. Shippers would not get the benefit of the hands-on, low-cost service that short line railroads provide, and we do not believe that there is anything in the 25-year history of the short line sale and lease transactions since passage of the Staggers Act that would justify such a result. Thank you. I'll be happy to answer questions.
Thank you. Mr. Gray.
Thank you. Chairman Buttrey, Vice Chairman Mulvey, I'm John Gray. I'm appearing on behalf of Union Pacific Railroad. I'm the Executive Director of the Interline Group at Union Pacific, which, among other responsibilities, has our relationship with short line and regional railroads. Because we have...
Would you adjust your mic so you can speak directly into the... There you go. So there's people in the back who I don't think can hear you.
Okay. Because we have already submitted written testimony in this, I'll keep the remarks brief, but I would like to emphasize 4 points that we think are important in respect to the transactions that we have undertaken and how we look at the transactions for the creation of short lines. First, we think that the short lines that have been created through this mechanism are in the public interest, and that the interchange commitments that go along with creation of these short lines is an integral part of the transaction. We think that the short lines benefit all parties involved in the in one form or another, the Class 1, the short line obviously, and the customers that are served by the short line. They also, as has been noted earlier, they also benefit the rail network as a whole. They benefit the Class 1, particularly by allowing it to concentrate capital spending on those lines which are most able to utilize the capital that we create. In short, our long distance, heavy density lines. We think that the spin-offs of two short lines create railroads that bring management closer to the business needs of specific customers. We feel that the short lines focus more closely than we can as a large railroad on local issues and local concerns involved in maintaining and improving service to existing customers and promoting the growth of rail business on low density lines. They also have the flexibility, some flexibility that we do not, in creating lower cost, high service structure that can attract more business from overcrowded highways, hopefully. We believe that they have been successful in doing this, and that we've seen the organic growth of our manifest business on short lines to change upwardly at a level considerably higher than that we see from the rest of the Union Pacific. In short, the short lines are an important mechanism for growth in our industry. The spin-offs allow us to continue to efficiently provide full service to all customers located on low-density lines, an area that we could see with the capital allocation process that over time could otherwise degenerate. It allows us to focus more of our resources on the core portions of our network, which benefits all the customers in that network. In our experience, the most effective approach for achieving these objectives with the spin-offs is to lease the lines to the short line for little or no rent, usually for no rent, and that's most of the transactions that we have are on that basis. Because the short lines do not pay any rent, they pay nothing for the use of the property. They can focus their resources, the capital that they have, their people, on maintaining and improving existing property and services and growing their business. It's not the only approach to creating a short line. We've used others, as have our predecessors, but these other approaches have to fit specific conditions. But transactions that include interchange commitments share a key feature. They allow the short line to reduce or eliminate the out-of-pocket payments that they would otherwise have to make for that line. In our experience, most, if not all, spin-offs that include interchange commitments would not have occurred without them. That the cash simply was not available to do that for the short line. In these transactions, our compensation comes not from the upfront payments, but charges from the revenue that we continue to earn on existing traffic and any growth of traffic that we may experience with the short line. Any revenue we earn from the new business that the short lines develop. If short lines could not commit to interchanging traffic with UP would have to set a lease or sale price high enough to account for the loss of potential loss of revenue, and not just the loss of revenue, but loss of margin from those transactions, if the traffic were interchanged with other railroads. Most short lines would or could not pay those prices, so the spin-offs would not have occurred. The second point that I'd like to make is that interchange commitments do not reduce shippers' competitive options. Union Pacific uses the interchange commitments only in transactions where customers have always had to route their traffic over UP. Our interchange commitments do not reduce these routing options. In fact, our spin-offs generally increase the routing options because the interchange commitments typically do not involve 100% of the short line traffic. There are provisions which do allow them to increase to interchange more traffic with other railroads than might have been the case where UP is still operating the line. Indeed, where our customers on short lines have had access to other railroads, either directly or through some type of reciprocal switch arrangement prior to the spinoff, we ensure that this access continues, even in cases where UP has had, in some cases, to pay additional charges to the short line in order to ensure that access. And in some cases, we have had to go in and subsidize the continued access for shippers to other carriers after the short line takes over. Moreover, as I've said, most spin-offs would not have occurred without the interchange commitments. In other words, the alternative was not a short line service without an interchange commitment. The alternative was and will be in the future continued service by our company, in which case the customers would not obtain many of the benefits that the short lines bring to the table. We might well have ultimately faced a decline in service, or in extreme cases, even abandonment of service.
Excuse me, Mr. Gray, excuse me. You've exceeded your time. I'm sorry. We can maybe pick up with the questioning portion later on. We need to be concerned about our time commitments so that we don't inconvenience other people in the audience. Okay. We need to go with the next witness.
Good morning. My name is Keith Gorman. I'm the Vice President and General Counsel of the American Short Line and Regional Railroad Association. I appreciate the opportunity to testify on behalf of the association today. Frankly, there is no single unified view about contractual interchange restrictions among the 425 member railroads of the ASLRRA. Our railroads are diverse in size, geographic location, and commercial position. And so it shouldn't be surprising that each member's opinion is informed by all those factors and more. A small number of our member railroads have expressed unhappiness with how paper barriers have affected their operations. However, we believe that the large majority of our member railroads who operate under contracts that contain interchange restrictions are satisfied and not dissatisfied with their effect on their operations. You will hear later directly from some short line railroads in this proceeding. Some are ASLRRA members and some are not. They will explain for themselves their views. My purpose is to make some observations about the impact of this issue on the short line and regional railroad industry as a whole. First, the ASLRRA strongly believes that the railroad industry agreement, to which it is a party, has been and remains an effective private sector vehicle in which to address issues about contractual interchange restrictions on an ongoing basis. Under it, the Railway Industry Working Group, which is represented today by Riley McCarran to my left, its co-chairman and himself a short line operator, has proven to be a useful mechanism to deal with complaints and requests for waivers of paper barriers. the vast majority, by the way, of which have been granted over the years. Indeed, while we have no data to cite, the effectiveness of the Railway Industry Agreement, at least for the large majority of railroads who have subscribed to it, is surely one reason that so few short lines have expressed concerns about interchange restrictions. As a private sector solution, the Railroad Industry Agreement is an illustration of the efficiency and economic revitalization which deregulation of the railroad industry has produced. Deregulation made today's short line and regional railroad industry possible. The shipping public is best served when the hundreds of members of our industry each are able to assess all the factors of their particular markets and based on that knowledge to freely negotiate operating contracts which take into account all of those individual circumstances. So it is that ASLRRA views with grave doubt calls for substituting regulatory solutions for the thousands of daily decisions of the marketplace reflected in bilateral contracts. In fact, ASLRRA believes that the mere discussion of potential regulatory intervention to forbid or limit interchange restrictions in private bilateral contracts between railroads has already had a chilling effect on the transfer of otherwise good candidate railroads from Class 1 railroads to short lines. Based on what we know about the economics of short line spinoffs, we believe that if regulatory restrictions are adopted which would constrain the ability of the Class 1 railroads to transfer something less than full operational control over their former lines, the creation of new short lines from former Class 1 lines will come to a virtual halt. In sum, ASLRRA believes that substituting a regulatory framework for the action of the marketplace would be a huge step backwards towards re-regulation of the railroad industry. It would certainly cause severe and disruptive short-term consequences and would set the industry on a course with unforeseeable long-term consequences, threatening the rail renaissance of the 21st century, especially for the short line segment of the industry. Thank you.
Thank you.
Chairman Buttry, Chairman Buttry, Vice Chairman Mulvey. My name is Riley McCarran. I'm the co-chair of the Rail Industry Working Group. That group was established in 2000 and is comprised of representatives of all 7 Class 1 railroads, as well as 7 Class 2 and Class 3 representatives, the Counsel of ASLRRA and the AAR, as well as staff advisors and experts as required. We meet quarterly and we hold conference calls in the intervening months. We are a successor to the Senior Management Committee and the specified in the original Rail Industry Agreement, and we administer that authority to interpret and amend the Rail Industry Agreement as required. We are a very active group. Not only do we meet on a regular basis, we frequently hold presentations at the Short Line Association regional and annual meetings to ensure that our members of the Short Line Association are fully aware of how the Rail Industry Agreement works. Our activity with respect to the Rail Industry Agreement has been most notable in the area of paper barriers, but we have also ventured into other areas such as car supply, interchange service, and equipment visibility. The Rail Industry Agreement itself was originally adopted in 1998 to attempt to bring some definition to the terms of trade between large and small railroads. It deals with a number of issues that at the time and presently pose some concern as impediments to growth of short line traffic. Again, notably paper barriers, but also terminal access, reciprocal switching, pricing discrimination, car supply, and interchange service are areas covered by the Rail Industry Agreement. With respect to paper barriers, the principles that the agreement applies are that only legitimate barriers should be enforceable, that barriers should not restrict a short line's ability to develop new traffic, and that is not only with respect to rates, which was much the focus of the previous panel, but also with respect to service and equipment. The agreement was redrafted in 2004 to better define new traffic so that short lines might be better able to avail themselves of the relief afforded by the agreement. We also have a provision where individual cases, should they not be agreed between the respective railroads, are mediated between the associations, the AAR and the ASLRRA, while issues of principle and interpretation are handled by the Rail Industry Working Agreement. Should neither of those avenues provide resolution, arbitration by the board is available to an unhappy short line party. In terms of relief requests, since January 2002, there have been 90 requests, formal requests, for relief under the Rail Industry Agreement. 67 of those have been granted, and one is still pending. Roughly 2/3 of those requests are paper barriers. Others involve different forms of access, trackage rights, and whatnot under the Rail Industry Agreement. However, far more of these paper barrier waivers are handled informally between short lines and class ones. The RIA essentially provides the backdrop, if you will, of what those terms of trade are, substituting, if you would, for case law in this area. In short, the RIA has been an effective mechanism to ensure that these contractual obligations between class ones and short lines, such as the paper barriers, don't inhibit the rail system from handling traffic that it should be able to handle. This is especially true with respect to new traffic opportunities, which refer not simply to new shippers, but to new traffic from existing shippers. We're an active industry body. We interpret the RIA, and we intend to continue doing so and adapting it to an evolving rail industry. Thank you very much.
Thank all of you again. Listening to this testimony, you think of a lot of interesting questions to ask.
Yes, that's what I was saying before, that you have all these written down and you think of more to ask.
Since I get to go first, if I were a short line railroad and I had an agreement with a class 1 railroad, and one morning I got up and said, I don't like being bound by these restrictions, and so I'm just going to ignore them in the future. So I proceed to do that. Is it true that the result of that decision would be that when I'm asking for access to the tracker, when I deliver that traffic to the main line, that I don't get access because of dispatching requirements or some other restriction? Is what enforcement procedure would be in effect under those circumstances? I bet that's never happened, but if it did happen.
I was going to say, Chairman Buttrey, that for us, we have not had that experience where a railroad with a commitment is refused to honor that commitment. Quite frankly, a lot of the process in this is basically you're dealing with honorable people, and so you don't have those issues. The fact is that operationally we do not have a lot of recourse. We are still obligated to do interchange with that railroad as if in any case, and to take care of that interchange appropriately, regardless of what other disputes there might be. The resolution for something like that, unfortunately, would have to be through legal processes, not through operational processes. The fact is that whether we like what the short line may be doing on, would like what the short line was doing on something like that or not, we would have to resolve it not through operational issues that hurt both ourselves, our customer, and the short line, but through the legal process.
So the avenue of approach, the initial avenue of approach would be through your organization. But you said there's a lot of cases still pending that haven't been resolved, which might fall into that category I just mentioned. Is that correct or not correct?
Well, we only have one case currently pending. We had 67 that had been resolved favorably to the short line. There were 22 that were not resolved favorably to the short line out of the 90. Our group
which means that the short line was relieved of whatever it was that they were asking for relief from. Is that correct?
If it was resolved favorably, yes, they received the relief they were asking.
Okay.
If in the 22 cases they did not receive the relief that they were seeking under the agreement. Right. In some cases, in many cases, because there was a disagreement as to whether or not traffic was truly new. I would say if it is a gray area with respect to whether or not traffic is prohibited by the contractual terms under, in the overall tapestry of the rail industry agreement, then yes, we would see it before our group. If it's a peculiar issue of contract, or if it is simply we're going to do what we want, come and get us, then that would be resolved between the two companies. I'd say that in my past experience at Wisconsin Central, we did have circumstances where we had contractual issues with a Class 1 carrier over exactly what the meaning of those restrictions in the contract were. They were always negotiated out. Traffic never stopped moving, and customers were never directly affected.
And the traffic was switched as if nothing ever happened.
Exactly.
Okay. But the recourse for your organization is only for railroads.
That is correct.
A shipper would not be able to come to you and say, I can't get railroad XYZ to do whatever it is I want them to do.
That is correct. Their railroad would have to advance that cause on their behalf. Mm-hmm. The rail industry agreement is an agreement between railroads.
Right. Thank you.
Thank you. Antitrust law identifies 4 primary indicia of reasonableness of a restrictive covenant, interchange agreement, whatever you want to call it. And those 4 are: 1, the restraint is ancillary to the main purpose of a lawful contract. 2, restraint is neither imposed by a party with monopolistic power nor forced as a monopoly. 3, the restraint is partial in nature and reasonably limited in time and scope. And 4, the restraint is not greater than needed to afford fair protection to the parties and not so extensive as to interfere with the interests of the public. We'd like to have all 4 of these to be reasonable. In your opinion, do paper barriers pass this test, and why?
Well, the transaction that the parties enter into is not a transaction where the interchange commitment is ancillary to the transaction itself. In this case, this is not a transaction.
You said that the transaction would not occur if it wasn't for the agreement. So
the transaction would not occur. Yes, okay. The interchange commitment is integral to the transaction.
So it's not ancillary then?
We would not say it's ancillary because this is an agreement not among parties where one of the parties may ultimately end up being in competition. Here, this is between 2 parties which are entering into a cooperative venture, an arrangement, a long-term joint venture, however you want to characterize legally. The cooperative arrangement between the parties to jointly serve the customer. The same as a joint venture, there wouldn't necessarily be any limitations on the time of a joint venture arrangement. It would be as long as the parties so desire. So the comparison of non-compete agreements, or the application of non-compete agreements, is really inapt in this circumstance.
Anyone else want to? Well, in your testimony, written comments, and just now, you claim that the analogies to non-compete agreements and other antitrust restrictions are inapt, and that interchange commitments establish, quote, a cooperative arrangement, not a competitive rivalry between the buyer and the seller. Yet isn't it true that paper barriers disadvantage a competitive routing offered by the buyer and another Class 1 railroad? And isn't that the competition that paper barriers wind up stifling?
No, we would submit that the transaction itself creates the cooperative arrangement. That cooperative arrangement is for the through service from the short line through the line haul transportation. Each transaction and each interchange commitment is somewhat different. As we indicated, no one size fits all. These arrangements depend upon, the transactions could include different types of arrangements, such as support arrangements, where the Class 1 provides marketing services, provides cars. Some do, some don't. There could be different amounts of payment that would be made or foregone if there are these types of arrangements. These are cooperative arrangements. The relationship is between the two parties for the provision of the through service. It is not at the downstream point.
I think I heard you say that these agreements between short lines and Class 1s, even if they were approved under 10901 or 10902, somehow have some type of umbrella protection under the other provisions of the Act for Antitrust Immunity. How do you get there?
Well, I think as Mr. McBride and other members of the previous panel indicated, I think there is some question as to the extent to which any antitrust protections are afforded parties as a result of the overall jurisdiction of the STB with respect to the transaction under concepts of primary jurisdiction or applied immunity. There's also the question of standing that was referenced. So it's an open question as to the extent to which there may be some antitrust protections that are afforded even though there is no specific statutory immunity. But let me add also to that point as well that even though there may not be the application of the antitrust laws because of some protections that might exist, we believe that these are not, these interchange commitments are not unreasonable restraint of trades that would be in violation of the antitrust laws. Any contract contains some sort of restraint of trade. Contracts such as overhead trackage rights agreements, haulage agreements, contain restraints of trade in terms of limiting what one party will do in a transaction in consideration for that limitation. What the courts and what the law prohibits are unreasonable restraints of trade. And we would submit there are three tests to determine whether it is unreasonable in any context. And one is whether or not there is any lessening of efficiency if the transaction creates inefficiencies. Here we would submit that the transaction itself enhances efficiency by providing better service and perhaps preserving service on a line where it otherwise might not be available. Secondly, is there any anti-competitive effect from the transaction? And I think we've shown, and I don't think anybody has disagreed with the fact that this does protect the status quo competitively. The customer on the line has no less competitive options from a rail standpoint than it did prior to the transaction. It has no less rights or remedies before the board than it had prior to the transaction. And third, does any party to the transaction have greater market power as a result of the transaction than it did before? And here the Class 1 railroad has no greater market power with respect to the ability to route traffic over its lines than it did prior to the transaction. We believe that the interchange commitments in these contexts meet all three tests and would not be found to be an unreasonable restraint of trade under the antitrust laws.
The testimony that was given by some of the witnesses that were on just before you, I'm not exactly sure whether you were in the room or not and heard those, which would seem to suggest that the opposite is true, that there are a fair amount of cases out there, actual cases out there, where these conditions or provisions or agreements do impede the ability for shippers to elect to use some other carrier or be switched to a different carrier or something like that. And that's a different question, really, from whether they're anti-competitive or not. It's a question of whether it grants them
option, if you will, for service into their location.
Yes, but again, I would submit that that shipper is in no worse position after the transaction with the interchange commitment than it was before. It didn't have that option before. It doesn't have it after.
But it does create a barrier to entry. To the extent you consider that market, that that you now have to be a market, you are with that contract erecting a barrier to entry. And in fact, one of the indicia that I mentioned before was that the restraint was partial in nature and reasonable and limited in time and scope. Now, these go on in perpetuity, and one of the criticisms of paper barriers are not that they not necessarily are not useful for facilitating transactions, but that they go on forever. Would you want to comment on that?
Well, first of all, the fact that they go on forever or go on for longer periods of time could be consistent with, or is consistent with the relationship, the cooperative relationship that is created between the Class 1 and the short line in the transaction. Also, that the length of time reflects, as I mentioned before, the consideration and the assumptions that go in to the transaction on behalf of each party. When the Class 1 goes into a transaction, there are a number of different considerations that it has to be involved with. One, of course, is the value of the line, how it would determine the value of the line. One would be what the expected revenues would be on the line. One would be what type of service it intends to provide, the amount of traffic it expects, the time it expects that traffic to flow. You can't say in any one particular instance that a length of time is unreasonable, too long, or too short.
Well, but infinite is a little different from a fixed amount of time. Every transaction has a value to the Class 1 and the short line, correct? There's a monetary value that you could attach to it, and you could recapture that value over some defined time horizon, rather than an agreement that would keep the stay in place in perpetuity. It could be 5 years, it could be 10 years. It would be a trade-off between the amount of discount you want to give the short line in taking over the traffic and how much they would have to pay for it. So if you accepted a smaller amount and said, okay, but for 5 years you're going to have to give us this traffic and you can't interline with anybody else, that would compensate you for the discount, would it not? Well, and still give the shipper the eventual opportunity to have another carrier.
Well, at the outset, I want to go back to the question of who it is that is being affected by this. The shipper, again, is in no worse position before the transaction or after the transaction as it was before the transaction. The question here is what is fair, what is unfair, as between the parties involved, between the two carriers. And as we've seen with very few exceptions, the carriers are not complaining about the terms of the transaction.
At least not publicly.
As well. Well, because again, it is a win-win situation for them. So these again were entered into on an arm's length basis with assumptions and terms that made sense and were of value to the parties involved. Again, without any reason from an anti-competitive standpoint, for a misrepresentation standpoint or the like, to change those terms. There is no basis for making that change.
When you say you'll change the competitive environment, however, you're talking about the current, the present. But a barrier to entry is something that precludes future competition, precludes future entry. And one of the charges that the chairman and I have is to protect the public interest. And the public interest is not only today, but it's also the future, whether or not new firms can come in and enter and compete. The whole presumption of deregulation was to promote competition and let the market decide. When you have these restrictive covenants, don't you in fact frustrate the market solution?
When you say firms coming in to compete, if you're talking about shippers.
No, firms coming in to compete. The short line railroad competed by serving another.
Well, they're the short line railroad again. These are all arm's length negotiations. The short line doesn't have to enter into the transaction. And in many cases, there aren't paper barriers, as Mr. Gray had indicated, in transactions. So again, these vary depending upon the circumstances, the consideration, the expectations of the parties. Some may have interchange commitments, some may not.
Vice Chairman Mulvey, could I provide a different view on the future for you?
Please do.
I think there's another angle to this, which is that the spin-offs of these lines to short lines are very, very important in preserving the competitiveness of our merchandise carload network. And I think with the panel previous, which very heavily represented utility coal interests, large chemical companies, these sorts of facilities are very much in the minority in the short line world. Generally, those facilities are on lines that are retained by Class 1s, but there are some in the short line world. But the people who are shipping boxcars of brown paper and gondolas of scrap, that is the business that is most at risk in the rail network, and that is where short lines have been most effective at retaining that business, increasing the railroad's participation in that business. And to give a real world example of this, one of the we recently at the Arkansas and Missouri, where I'm the principal owner, jointly with the Missouri and Northern Arkansas, which is one of the railroads at issue here in paper barriers with respect to a utility coal plant. We jointly received a marketing award for a new movement we developed of construction sand from Van Buren, Arkansas to Branson, Missouri. Now the Missouri and Northern Arkansas had to get a paper barrier waiver from the UP to handle that traffic, which they did. However, I think I could say categorically that if that line was still owned by the Union Pacific, their economics would have prohibited them from handling that traffic in an economic fashion. And now that line has been in short line hands for a long time now, about 15 years, give or take. But I dare say that had the Union Pacific known ahead of time that they would potentially bring their arch rival into a service position at two utility coal plants that are also located on that line, they never would have leased it into the short line world, and therefore the beneficial effects, not just on our traffic, but on many other merchandise traffic shippers, people shipping frozen foods and coiled wire rod and llamas and things like that, those beneficial effects would never have taken place. So I think a very real public policy question here is that if these sorts of contractual restrictions are not permitted in the future, and devolution of lines into the gathering lines into the short line world comes to a halt, as a couple of our other witnesses have suggested, that a very positive evolution of the rail system as a whole will be halted.
I'm sorry, go ahead.
Yes. To continue answering, if I could, part of Vice Chairman Mulvey's question on some of the time frame of the interchange commitments. To my knowledge, Union Pacific doesn't have any interchange commitments that are perpetual. They are consistent with the term of the lease of the line. In some cases, we found that a lease of the line has to be at least 20 years to provide the short line enough time to make investments in the line and recover those investments, that you can't do it for anything less than that. However, at the end of that lease period, that interchange commitment, like all other terms of the lease, are renegotiable and include the opportunity, if the interchange commitment is not there, to begin charging rental for the line. Certainly, we would not lease it for free if the interchange commitment were not in place. So there is always that flexibility downstream, that the interchange commitment can disappear at the end of the term of the lease. But there are, as I believe as Riley said, there are consequences one way or the other, economic consequences, which have to be accounted for as a part of the termination of that interchange commitment. Potentially, it could be renewed at a zero-cost lease, or it could be put into some form in which we would charge for the lease, or the line could be sold. Now, I want to emphasize that where we have sold lines, and occasionally we do have a line sale, if that line sale is for what we perceive to be the going concern value of the line, then there are no interchange commitments involved with that line. Rarely do we find a short line that believes that the line that it would be buying is worth the economic value to pay the full cost of that line. That inevitably there is greater value, there is greater ability to ensure that the line continues in operation if we have it at a low-cost sale, or a no sale, or with a lease at no cost with the interchange commitment in place.
Do you have any data on how many of these agreements exist where paper barriers have been renegotiated or liberalized or bought out? Or that's for all of you, I mean, just industry-wise?
I have no information on the industry. I can tell you for UP what we have. We have, depending upon how you define the interchange commitment, it can be between 25 and 29 that we have in place with various railroads. All of them spin-offs from Union Pacific. There is no such thing as an interchange commitment with a railroad that's not a spin-off for us. And as far as renegotiation, there have been I don't believe there have been any that we have renegotiated to date, simply because we'll start seeing the first of the lease turnovers that took place in the late 80s start coming up within the next couple of years.
Well, that will be requests for waivers then. In terms of waivers.
In terms of requests for waivers?
Yeah.
Oh, in that, I believe we've had about 50 waivers. Of those, I believe we've granted all but 3 or 4.
There are 50 waivers of paper barriers?
Of paper barriers of various types for us.
Because usually those 67 waivers were granted. So that's different from the ones. In other words, they had ones they did directly, and the other ones went to you. And of the 90 requests for waivers for paper barriers and other things, 67 were granted.
That's correct, and we consider those to be the formal requests made pursuant to the agreement. There are others that are handled informally.
We need those. I'm sorry.
This is statistics-wise, of the 67 paper waivers, what percentage of those were for paper barriers? You said about 2/3?
Of the total 90, about 2/3 were paper barriers. I don't have the percentage for the 67 because
theoretically it could be 50-50 then, because if 20 were rejected and they were all paper barriers, then you would have about 50-50.
Yeah. I would say that I have been co-chairman of the committee since late 2002, so for most of this period, and I would say that in general the paper barrier statistics mirror the total during that time frame. So I would expect you could simply take a pro rata. In the first couple of years of data keeping, it simply wasn't broken down by type of relief request.
There was some testimony earlier, I think that there are paper barriers out there that prevent build-outs. Are you aware of whether that's the case with your company or not?
Well, we don't have any paper barriers in place that specifically address build-outs. However, the situation, you would have a situation where if a carrier is contractually committed for interchange to us, if someone built out to that carrier, or that carrier built out to another location, then those commitments would apply on any new traffic that was developed as a result of that build out. Now, I'm not sure the exact facts that were mentioned earlier in the Minnesota case. I don't believe that was related to any of our shoreline spinoff carriers.
So car charges and things like that might be applied to that build out traffic.
Well, as I say, nothing changes from the perspective of the small railroad, the short line that has the commitment. If someone builds out to them, they are still obligated for the business that comes from that build out. They would still be obligated to interchange that with Union Pacific under their agreements with us.
Okay. Were any of those waivers that you spoke of waivers from any kind of build out restrictions?
Not to my knowledge. No, they were for business on the line as it existed.
Okay. Do you have any more questions?
I do, but I think it should move on.
Okay. Thank you very much.